A lot up for discussion in a Boise courtroom in the case against Brian Kohberger, but some of the most compelling centers around the alleged murder weapon. The defense says they have an expert who says the Amazon data, pointing to a knife purchase, can be explained away and thus excluded. Frustration from the defense that the state is oversimplifying the evidence.
The state wants to apply argument. In an argument, they will apply intent to purchase a K-bar to get to November 13th, 2022.
We applied for and we were granted a search warrant for Brian Kohberger's Amazon.com user activity. The search warrant was narrow in scope to items related to the homicide and evidence related to the seizing of knives. In this case, it was knives and knife accessories.
Another pivotal part of the puzzle centers around the use of DNA evidence. Now, specifically looking at whether terms like touch DNA could mislead jurors, plus whether data deemed inconclusive can be presented to a jury.
Touch DNA does not mean now that someone touched something. It simply means that in some mechanism, DNA from a person has gotten to an object, whether that's through direct or indirect contact.
The state's theory here is that one would not expect the perpetrator's DNA to be under her fingernails.
They also spend time discussing inflammatory language and how Brian Kohberger will be portrayed during trial, asking to bar words like sociopath and psychopath, and murder. Both the judge and the state noted the state has no intention to use the words psychopath or sociopath, but due to the nature of the first-degree murder charge against Kohberger, the word murder will be hard to avoid. The state also noted they do not intend to use any of Kohberger's characteristics of autism spectrum disorder as evidence of aggravating factors during the trial or potential penalty phase.
We want to be able to present, if we get to a mitigation phase, his autism and how that works and how he's learned to live with the conditions that he has.
To be quite frank, if we get to a penalty phase, we have a lot better aggravating evidence than the fact that he has level 1 autism. And frankly, it's just not a persuasive argument to ask a jury to impose the penalty of death because someone has autism.